Lane, the Gypsy Rose Blanchard case, truths unfold.
Hey there, friends. We are going to be going over the FOIA that Into the Weeds podcast has so graciously allowed many of us creators to cover. This is going to be broken up into several different parts. Today, we're going to be covering the motion to vacate, set aside, or correct judgment and sentence for Nicholas Godejohn. Comes now, movement Nicholas Godejohn, and by through undersigned counsel, and moves this court for an order pursuant to Missouri Supreme Court Rule 29.15 to vacate, set aside, or correct the judgment of his convictions of murder in the first degree and armed criminal action, and his concurrent sentence of life without parole and 25 years in the Department of Corrections in Greene County, case number 1531-CR 03590-01. In support thereof, Mr. Godejohn states as follows. Number 1, place of detention, the Potosi Correctional Center address. Number 2, sentencing court and location, the Honorable David Jones Division 2 in the Circuit Court of Greene County, Springfield, Missouri. Number 3, case number and offenses being challenged. Greene County case number 1531-CR 03590-01. Count 1, murder in the first degree. Count 2, armed criminal action. Number 4, sentencing dates and terms. On February 22nd, 2018, Mr. Godejohn was sentenced to life without parole on count 1 and 25 years on count 2 to be served concurrently. Number 5, findings of guilt made after. Jury verdict of guilty after trial occurring on November 8th through the 6th, 2018. Number 6 and 7, appellate proceedings. Southern District case number SD 35974. Mandate issued September 30th, 2020, affirming the judgment. Number 8, state concisely all the grounds known to you for vacating, setting aside, or correcting your conviction and sentence.
There's also experts hired by the Public Defender's Office. I'm assuming you have no objection to that.
It's relevant whether an expert has worked for one party or the other party. Specific to the Public Defender's Office, I agree, but with regard to whether the expert has worked for the state or the defense, that is certainly relevant.
I would agree with that. I just don't want you to be mentioning that the Public Defender's Office.
8A, ineffective assistance of counsel. Failure to investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder, Asperger's, and guilt phase to support a diminished capacity defense. Nicholas Godejohn was denied effective assistance of counsel, a fair trial, due process, and was subjected to cruel and unusual punishment in violation of his rights under the 5th, 6th, 8th, and 14th Amendments of the United States Constitution and Article 1, Sections 10, 18A, and 21 of the Missouri Constitution, and that his trial counsel failed to fully investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder to support a diminished capacity defense. Counsel failed to exercise the customary skill and diligence that a reasonably competent attorney would have exercised under similar circumstances.
As I understand it, have I stated this correct at this point?
Yes, sir. Just to give a little bit further background, this case was actually set for trial in front of Judge Coleman. And very close in time to that trial, the defense moved to endorse Dr. Franks as an exhibit, and we filed an objection to the late endorsement of that witness. Then we had the offer of proof. Judge Coleman ruled that he would allow the testimony. At that point, I filed our motion under Rule 25 for good cause shown for a state examination. On December 20th, or 22nd of 2016, the defense agreed to the granting of that motion.
Well, and that was a question I had because there is a docket entry showing Mr. Perry. I believe it says with joint consent, something to that extent.
It says sustained by agreement. Because there were discussions at the time delayed endorsement because we all understood the pretty settled state of Missouri law at that time. There was an agreement that because of the late endorsement, it'd be necessary to continue the trial so the state could obtain its middle examination under Rule 25, and that motion was granted by agreement. And then ultimately, after Dr. Denny did his exam, the state moved to endorse him, and he was endorsed without objection by the defense.
Now, I see in your, would that be a correct?
That is good. Also remember, the Brothers case didn't exist at the time, and I really had no case law that would have permitted me to successfully argue the state didn't get to do it. So, I mean, you got to look at it from my context at the time. However, the case law came down interpreting the law that was in existence at the time. And the Carruthers case came down and said that the state's not allowed to do that. Now, remember, in the Carruthers case, a second middle exam was conducted anyway, as you know. And the Carruthers court excluded it after it was conducted, which is what I'm asking. Because the law has changed on this issue, as the court knows. Diminished capacity is not an injury defense. It is simply making the state prove an element. All it is. It's evidence presented on the element itself. So we're not raising a mental health defense here in the traditional sense. And for that reason, the state was not entitled to it at the time. And I believe the court ought to do what the Carruthers court did, and that is, despite the fact that the exam was conducted to exclude it as having violated the rule 552, which does control the situation.
Although it wasn't under 552, it was under.
I realize that, but it's still a 552 motion. I mean, it's a mental health request.
Now, certainly the burden has changed, as referenced in the jury instructions. You're correct that it's not the same as an NGRI. It's my understanding, Mr. Patterson, that you, out of an error, to try to avoid error and out of an abundance of caution, have agreed that you will not introduce testimony concerning your expert's examination of the defendant. Is that correct?
Yes, sir. If I could clarify a couple other points. One, Carruthers in the Eastern District opinion is currently pending a motion to transfer filed in the Missouri Supreme Court that has not been ruled upon. That decision is also contrary to prior decisions of the Eastern District in State versus Dixon and State versus Wayne, which I cited in a footnote in my motion. But because of the uncertainty caused by the Carruthers decision, I've spoken with Dr. Denny. He will be able to testify and form opinions based upon the investigative records and the work done by Dr. Franks, the defense expert, and in order to testify those opinions will not need to refer to his own examination and testing of the defendant. The defense motion is overbroad to exclude Dr. Denny's testimony in its entirety. If we were to say Carruthers control, the only thing that would be excludable is that examination and testing done by Dr. Denny. In fact, Carruthers specifically notes
it affords the state the opportunity to put on an expert,
right,
to challenge basically the basis for the defense expert.
Right, to do exactly what I'm proposing.
Nicholas Godejohn was prejudiced as a result, and that had counsel not been ineffective, there is a reasonable probability that he would not have been convicted of first-degree murder and armed criminal action, and would not have been sentenced to life without probation or parole in 25 years. Counsel was aware, or should have been aware, prior to trial, that Nicholas was diagnosed with autism as early as second grade and with Asperger's syndrome in high school. Counsel was aware, or should have been aware, that autism spectrum disorder, known as ASD, refers to a group of complex neurodevelopment disorders characterized by repetitive and characteristic patterns of behavior and difficulties with social communication and interaction. Counsel also was aware, or should have been aware, that the symptoms of ASD are present from early childhood and affect daily functioning.
Yeah, she was deeply involved with it. I mean, just like it says in his plea statements, like I said, right while I was talking to them, it says just pretty much word for word what I told them. She told me before I ended up getting there in a text that there was latex gloves that be on the porch. She did say that. Right on the text is it's clear as day that you can actually see it.
Living on my own has really been a good experience. I make sure I take care of my responsibilities around the apartment, cleaning, cooking for myself. Independent living means doing your laundry, have goal settings, public transportation, a lot of good stuff.
That autism is like a puzzle, and it can be very confusing to a lot of people.
We don't know anything about autism. And I just want autism to be cured.
Counsel was aware, or should have been aware, that there are structural brain differences in someone with ASD compared to those without ASD. Counsel was also aware, or should have been aware, that for 3 years prior to the offense, Nicholas Godejohn and Gypsy Blanchard engaged in an increasingly intense online relationship, which included sexually explicit online chats and videos made by Gypsy and sent to Nicholas. Counsel elected to put forth a diminished capacity defense at trial. Once that decision was made, counsel had a duty to retain a competent, qualified expert with substantial practical experience in evaluating and treating individuals with autism spectrum disorders, such as Dr. Theodore Westerman, and to investigate and present evidence on how Mr. Godejohn's specific mental disease and defect and the facts of the case support a diminished capacity defense. Counsel's failure to do so fell below the standard of care that a reasonably competent attorney would exercise in similar circumstances. Evidence that the defendant did or did not suffer from a mental disease or defect is admissible in a criminal prosecution to prove that the defendant did or did not have a state of mind, which is an element of the offense. Under Section 552.015.28, Revised Missouri Statutes of Limitations, this is commonly known as the defense of diminished capacity. State versus Walkup. When first recognizing the diminished capacity defense, the Missouri Supreme Court defined it as proof of a mental derangement short of insanity as evidence of lack of deliberation or premeditated design. In other words, it contemplates full responsibility, not partial, but only for the crime actually committed. Quoting State versus Anderson. In Walkup, the defendant was convicted of first-degree murder for stabbing his girlfriend to death. At trial, court excluded the defense's attempt to present expert witness testimony that would have made it less likely that he would have deliberated before killing his girlfriend. The Missouri Supreme Court reversed and held the defense expert's proposed testimony, and that the defendant had suffered from bipolar disorder at the time of the offense, was logically and legally relevant to the issue of whether the jury should believe the state's evidence that he acted with deliberation. The Walkup Court also held that the notice provisions of Section 552.030 Revised Missouri Statutes of Limitations did not apply to diminished capacity evidence under Section 552.015.28 Revised Missouri Statutes of Limitations. For purposes of a diminished capacity defense, the terms mental disease or defect include congenital and traumatic mental conditions as well as disease. Section 552.010 Revised Missouri Statutes of Limitations. Prior to trial, counsel retained a clinical psychologist, Dr. Kent Franks, to evaluate Mr. Godejohn for competency. Dr. Franks found Mr. Godejohn competent to stand trial and provided trial counsel with a report to that effect, and also diagnosed Mr. Godejohn with autism spectrum disorder level 2.
You solemnly swear that the testimony you're about to give in the cause now pending before the court will be the truth, the whole truth, and nothing but the truth so help you God. I do.
I actually don't think that's the appropriate ruling. I think you may allow him to testify as an expert. I don't think it's proper for the court to declare anyone an expert to comment on their qualifications.
I think that may be the actual methodology. But
We would ask that, Judge.
I will allow Dr. Franks to testify on the area of forensic psychology.
Are you familiar with autism?
Yes.
Tell us what autism is.
It's a neurological disorder. It's considered brain-based, and it's characterized by two different things. The first is impairment in social abilities. And then the second prong is repetitive stereotype movements.
Overall, what do these tests tell you about Nicholas Godejohn?
That he has an autism spectrum disorder. Characterized by severe deficits in social understanding, social reciprocity, understanding nonverbal cues, understanding emotions, and then an insistence on sameness, inability to venture outside of his house, and the collective behaviors that's characteristic of the disorder.
And did you draw an ultimate conclusion regarding, to a reasonable degree of psychological certainty, what did you diagnose Mr. Godejohn with?
Autism spectrum disorder, level 2.
Anything else that you added to that?
No.
Anything about support?
Requiring substantial support with accompanying intellectual impairment.
And was that part of your diagnosis?
Yes.
What does that mean, requiring substantial support with accompanying intellectual impairment?
It's a specifier in the DSM-5. It means that he requires substantial support in order to be able to function adequately.
Requiring substantial support with accompanying intellectual impairment. This report was provided to trial counsel on September 28, 2016. On October 11, 2016, trial counsel informed the court that the defense in this case would not be NGRI, but that Mr. Godejohn did not have a state of mind, which is an element of offense deliberation in this case. The record reflects that as early as October 11, 2016, it was the intent of counsel to put forth a diminished capacity defense. Since counsel knew that Mr. Godejohn had been diagnosed with autism as a child and Asperger's syndrome in high school, and that Mr. Godejohn's relationship with Gypsy Blanchard was an important aspect of the case in regard to whether or not Mr. Godejohn was able to deliberate at the time of the offense. It was incumbent on counsel to investigate and present evidence from a qualified neuropsychologist who had expertise and experience in the area of autism spectrum disorder and Asperger's syndrome. Instead, counsel chose to keep Dr. Franks on the case and call him to testify to Mr. Godejohn's mental disease or defect and his inability to deliberate at the time of the offense of the trial. At the pre-trial hearing on October 11, 2016, the prosecutor objected to the defense calling Dr. Franks as a witness to support a defense of diminished capacity and argued that he should be excluded for late endorsement because Dr. Franks' report did not mention anything about the defendant's ability to form the mental intent required to commit the crime. Judge Holden informed trial counsel that he wanted to hear the testimony of Dr. Franks as part of his decision on whether or not Dr. Franks' testimony would be excluded at trial. A hearing was set to hear defendant's offer of proof of Dr. Franks on November 30th, 2016. On November 30th, 2016, an offer of proof hearing was held on whether or not Dr. Franks could testify at the trial. During the hearing, the court asked the state whether or not they thought Dr. Franks was an expert. Mr. Patterson answered, "I think in this particular case, there are grave issues with that, and that his testimony is more likely to mislead the jury, given his lack of knowledge on the specific topic he's been called to testify about." At the close of hearing, the state argued that Dr. Franks was not qualified to render an expert opinion on the issue of diminished capacity. Mr. Patterson stated on the record that Dr. Franks does not know what deliberation means under Missouri law, and that he was not qualified to testify as an expert in regard to a diminished capacity defense because Dr. Franks is simply not qualified on the issue and does not understand what he is talking about. So I really want to weigh in on this because it does go both ways. And I did watch this trial. Nick's defense really dropped the ball here. So while it seems good that Patterson is objecting to Dr. Franks' testimony, it's really shady. But it's even more shady that Nick's lawyer, Attorney Perry, knew for a fact that Dr. Franks is a forensic psychologist and not a neuropsychologist. He has no specialty in ASD and Asperger's. Dr. Franks admits to this on the stand, but claims he's been trained to provide testing for such. So the reason Patterson is objecting is because Dr. Franks diagnosed Nick with ASD level 2 requiring support. Naturally, Patterson doesn't like this. He's trying to destroy the defense, right? He's got to get his conviction. Perry basically handed him the trophy to do so, knowing good and well that this would get excluded for that very reason. During the motions hearing before trial, Perry was made fully aware of this, but the judge wanted to hear Dr. Franks' testimony. Anyways, I just wanted to point out, both sides dropped the ball on Nick, even though Dr. Franks himself said it's clear as day he needs support. Dr. Franks is a forensic psychologist who will usually testify in cases where the defendant's defense is reason of insanity. That's not Nick's defense. Nick's defense is diminished capacity. While there are similarities of the two defenses, they are different. So this is what dropping the ball looks like and what a true miscarriage of justice is. Dr. Kent Franks was called as an expert at trial in the defense's case in chief. Dr. Franks' CV was placed into evidence as defendant's Exhibit A. Dr. Franks does not have any practical experience or training in evaluating or treating individuals with autism spectrum disorder and has not published any articles or books related to autism spectrum disorders. This is in Defense Exhibit A. When testifying on direct examination, Dr. Franks was asked by trial counsel to tell the jury about his experience with people with autism. Dr. Franks gave the following answer.
Well, it wasn't added into the DSM until 1994. And so it's the disorder has been known since the 1940s. But as research has accumulated, it's become much more, clinicians are looking for it more than we used to because there's a lot more that's known about it. And so in the work that I do in evaluating people for the courts, I've learned how to administer the tests, I've learned how to identify it, and I've gone to training so that to increase my knowledge about the disorder over the last 10 years.
Although Dr. Franks' testimony at trial includes information parroted from the DSM-V about autism spectrum disorder, he is clearly not an expert in the field of autism spectrum disorders or Asperger's, and does not have experience in evaluating and treating individuals with autism spectrum disorder. Counsel knew Nicholas Godejohn had been diagnosed with autism and with Asperger's syndrome prior to the offense and was aware or should have been aware of Dr. Franks' lack of experience in evaluating and treating individuals with autism spectrum disorders. Therefore, counsel had a duty to investigate and present evidence to the jury from an expert with substantially more knowledge and practical experience than Dr. Franks to support a defense of diminished capacity. After the offer of proof hearing, counsel knew or should have known that Dr. Franks was not qualified to testify in support of diminished capacity defense based on Mr. Godejohn's mental disease of autism spectrum disorder. Dr. Franks was not an expert in autism spectrum disorder Asperger's syndrome and therefore not qualified to testify to his opinion on whether or not Mr. Godejohn, because of his mental disease or defect, was able to deliberate at the time of the offense. Counsel was ineffective for failing to investigate and present a qualified neuropsychologist such as Dr. Ted Wasserman, who is an expert in the field of autism spectrum disorders and who has substantial practical experience in evaluating and treating individuals with autism spectrum disorders. Had counsel hired the appropriate type of expert, a neuropsychologist with substantial expertise in evaluating and treating individuals with autism spectrum disorders and Asperger's syndrome, such as Dr. Ted Wasserman, counsel would have known that individuals with Asperger's disorder are extremely susceptible to social manipulation and suggestion by virtue of the following characteristics. Number 1, a greater need for emotional intimacy, both romantic and otherwise. Number 2, the fragile nature of their developing relationships. Number 3, social impairment. Number 4, empathy imbalance, deficit of cognitive empathy, which is being able to understand and predict others' mental state, but a surplus of emotional empathy, which is the capacity for attachment. And number 5, hyperfocus on a narrow range of interests. An expert neuropsychologist specializing in autism spectrum disorders and Asperger's would have explained to the jury at trial how these recognized and accepted characteristics combined with Gypsy Blanchard's methodical manipulation of Nicholas over a 2.5-year period resulted in Nicholas's inability to deliberate at the time of the offense. A neuropsychologist with substantial practical experience, such as Dr. Wasserman, could have testified that you cannot separate Nicholas Godejohn from his autism. He is always autistic. He would have further testified that Nicholas's autism combined with Gypsy's requests of him and her planning resulted in Nicholas surrendering his deliberation to Gypsy by taking what she said as fact. Example, killing her mother was the only way they could be together, and that it was up to Nicholas to rescue her from her abusive situation, and operating as such. Nicholas surrendered to Gypsy's logic. Dr. Wasserman, or a similarly situated neuropsychological expert, would have testified that these are characteristics of an autistic person. Further support for the opinion of an expert such as Dr. Wasserman was available to counsel through information from Nicholas Godejohn's family about his behavior over the course of his entire life, as well as over the time period he was involved in an online relationship with Gypsy Blanchard. From school records, hospital records, Social Security disability records, videos, and Facebook messages provided in discovery, and mental health records from the Waukesha County Jail in Wisconsin. Information from Nicholas Godejohn's family in Wisconsin would have provided anecdotal information familiar to an expert in the field of autism spectrum disorders, which could be used to support his findings in regard to diminished capacity. If counsel had investigated and consulted with a qualified, experienced expert who had substantial practical experience in evaluating and treating individuals with autism spectrum disorders, counsel would have been able to call this expert to rebut or respond to the state's expert witness, Dr. Robert Denny. In criminal case, the purpose of rebuttal evidence is to give the defendant an opportunity to rebut or respond to the state's rebuttal evidence. To be admissible in rebuttal, evidence must be relevant and otherwise admissible. Much of the testimony of Dr. Denny's rebuttal testimony regarding autism spectrum disorders was at the very least misleading and oftentimes incorrect. An expert who had substantial practical experience in evaluating and treating individuals with autism spectrum disorders, such as Dr. Ted Wasserman, would have been able to testify in rebuttal to Dr. Denny's misrepresentation of autism and Asperger's disorder. When asked by the prosecutor to explain why he agreed with Mr. Godejohn's historical diagnosis of Asperger's syndrome, Dr. Denny testified as follows.
Is of Asperger's syndrome?
Yes, I do.
Can you explain why that is?
Well, yes, I can. And to be fair, if we can't just say that, because his history started out with autism when he was younger. Because one of the things that would classify a condition as autism for young children is not only the communication problem and the perseverative kind of rote behaviors, collecting things, playing with things in an odd way, repetitive behaviors, but also delay in language functioning or general cognitive function. If the person had those delays as well, then it would be considered autism. If they did not have the language delays or overwhelming cognitive delays, then it was considered Asperger's. Okay, so that's the key difference there. And back then, when Mr. Godejohn was very young, there were indications of delayed language functioning at young ages. And so he was diagnosed with autism. Then once he reached high school, those areas caught up. So they were no longer relevant to his condition per se. And they fell away, which then changed the classification over to Asperger's, changed the diagnosis to Asperger's. And we don't know exactly why there was that delay there. Could have been a delay, but either way, he caught up. And so it was Asperger's. And I agree with that diagnosis at the time. I think it was correct.
Just talk a little bit more about it.
A qualified expert, such as Dr. Wasserman, would have been able to testify that Dr. Denny's description of the language development and functioning of an individual formerly diagnosed with Asperger's disorder is incorrect. There are early delays that self-correct, but adult language is truncated in several aspects. In addition, there is extant research which clearly demonstrates that there are real differences neuropsychologically between autism and Asperger's disorder. In addition, Dr. Denny concluded that Nicholas was mildly autistic. He testified that Asperger's was a very mild form of autism. Dr. Denny also testified that his diagnosis of Nicholas Godejohn was autism spectrum disorder mild or level 1. Dr. Denny's testimony that Nicholas Godejohn was mildly autistic is misleading, and his insinuation that autism level 1 is mild autism is actually incorrect. An expert who has substantial practical experience in evaluating and treating individuals with autism spectrum disorders would have testified on rebuttal that Dr. Denny is terming as mild merely reflects the superficial socialness of an individual with Asperger's disorder that masks ongoing significant social dysfunction. Dr. Denny appeared to use the word mild in a manner consistent with colloquial usage, meaning not severe, serious, or harsh, which implies to lay a person that the autism was hardly a factor at all and could be discounted. In fact, he used some version of the term mild over a dozen times during his testimony. A qualified expert would have pointed out on rebuttal that was a gross mischaracterization of the term mild when used in conjunction with autism for descriptive purposes. Despite the severity of symptoms, individuals with autism always have the same core deficits. There are strong and consistent commonalities in social deficits that result in individuals with ASD interacting with others differently. A qualified expert with practical experience in evaluating and treating individuals with autism spectrum disorders would have testified on rebuttal that certain symptoms must be present in order to qualify for a diagnosis of autism spectrum disorder. Even people with level 1 autism may have significant developmental and sensory challenges that are severe enough to get in the way of normal activities and relationships. Therefore, individuals suffering from high-functioning autism spectrum disorders are, by definition, impaired in understanding social cues and in responding to them. A qualified expert with practical experience in evaluating and treating individuals with autism spectrum disorders would also have testified in rebuttal that any person meeting their criteria for having ASD will be further diagnosed with having ASD level 1, ASD level 2, or ASD level 3. These levels specifically indicate how much support an autistic person needs, with level 1 meaning relatively little support is required, and level 3 indicating the need for a great deal of support. Nowhere in the DSM-5 is the word mild used in describing Asperger's disorder or ASD level 1. A qualified expert with substantial practical experience in evaluating and treating individuals in autism would have been able to testify in rebuttal that Nicholas Godejohn did not get the level of support he needed at home or in the form of services in the community. A qualified expert would have testified in rebuttal that this is evidenced by Nicholas Godejohn's Social Security disability records. Less than 7 months prior to the offense, Nicholas's mother, Stephanie Goldhammer, completed a Social Security benefits form in regard to Nicholas's disability, titled Social Function Report, Adult Third Party. In this report, Stephanie writes that Nicholas has a lot of concentration problems, is not comfortable around people, sometimes seems to have problems grasping the real world. She reports that Nicholas doesn't understand why you need to take a shower or why you clean your room. Nicholas's mother also reports that Nicholas is not capable of cooking an oven-prepared meal. Stephanie Goldhammer also reports on the form that the computer is a lot of his connection to people. He is always to himself. In addition, the prosecutor asked Dr. Denny if he had published a paper with regard to autism, and he responded, "Yes, I have." This one paper is also listed in Dr. Denny's curriculum vitae, which was put into evidence at trial as State's Exhibit number 187. The paper is entitled "An Estimate of the Prevalence of Autism Spectrum Disorders in an Incarcerated Population," and the primary author is listed as Rachel L. Fazio. The secondary author is Christina Peets, and Dr. Robert Denny is listed last, and the published date is listed as 2012. The School of Professional Psychology at the Forrest Institute is also referenced in another author section. In 2012, Dr. Denny was a professor at the Forrest Institute and also supervised doctoral students. A qualified expert with substantial practical experience in evaluating and treating individuals with autism spectrum disorders could have testified in rebuttal that the fact that Dr. Denny's name is third in line on this particular research paper does not make him an expert in the area of autism spectrum disorders. If counsel would have adequately investigated a diminished capacity defense with a qualified, experienced expert who had substantial practical experience in evaluating and treating individuals with autism spectrum disorders to determine whether Nicholas Godejohn suffered from a mental disease or a defect at the time of the offense, which precluded him from deliberating, counsel would have discovered that an expert such as Dr. Ted Wasserman was available and would have concluded to a reasonable degree of psychological certainty that 1. Nicholas Godejohn suffered from a mental disease or defect at the time of the offense, and 2. That due to his disorder, Mr. Godejohn was not capable of deliberating or of cool reflection at the time of the crime. Dr. Wasserman or a similarly situated neuropsychologist would have testified at the guilt phase of Mr. Godejohn's trial and will testify at any hearing granted in this case that because of his autism spectrum disorder, Mr. Godejohn's ability to deliberate at the time of the offense was non-existent, and therefore Mr. Godejohn did not have the ability to deliberate at the time of the offense. Counsel's ineffectiveness resulted in prejudice to Mr. Godejohn in that counsel's failure to investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder allowed the prosecutor to argue in closing that Gypsy did not manipulate Nicholas into killing her mother. The jury did not hear evidence about how Nicholas Godejohn's autism played a role in his relationship with Gypsy. Without this evidence being presented from an expert with substantial practical experience in evaluating and treating individuals with autism spectrum disorders, the state was able to make the following closing argument to the jury without any contrary evidence being presented by the defense. Quote, "And absolutely you heard as part of the facts that Gypsy did have a role. She was the one to ask the defendant to kill her mom. But we have to be careful and separate out what is collaboration versus manipulation. Because there could be this sense that because Gypsy was the one that asked the defendant somehow, she manipulated the defendant into killing her mom. Let's think about that for a minute. Think about the manipulation. It requires some kind of deception. I want to steal a car, so I tell you, hey, see that car over there? The owner said I could have it. It's okay. Could you just go and get it for me? That's manipulation. Because we're deceiving versus, hey, that car over there, I want to steal it. Do you want to do it for me? That's not manipulation. She asked him, but he said yes. And if you think about it, in a way, Gypsy asked in the least manipulative way because she didn't lie at all. She put it all out there. She didn't try to do it through innuendo. She didn't make things up. She just said, this is what's happening to me. Will you kill my mom? There's no manipulation there because ultimately it was the defendant's decision. Nothing was held back from him. And if anything was evident from the dynamic of their relationship that you saw on the Facebook and in the text messages, in the interview, and in Gypsy's testimony, Nicholas Godejohn was not made to ever do anything Nicholas Godejohn did not want to do. End quote. Counsel was ineffective for failing to investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder to support a diminished capacity defense trial during the guilt phase. Nicholas Godejohn was prejudiced by counsel's failure and that the outcome of his trial would have been different, and Mr. Godejohn would not have been convicted of murder in the first degree. A new trial must be ordered.
You must not discuss this case among yourselves or with others, or permit anyone to discuss it in your hearing. You should not form or express any opinion about the case until it is finally given to you to decide. Do not do any research or investigation on your own about any matter regarding this case or anyone involved with the trial. Do not communicate with others about the case by any means. Do not read, view, or listen to any newspaper, radio, electronic communication from the internet, or television report of the trial. It's 2:48. Why don't we recess for about 5 after 3, and we'll come back and continue talking. All right.
Did you guys just hear where the judge specifically told the jury, do not pay attention to newspapers, magazines, books, whatever, regarding the case, so it doesn't affect their decision about the verdict? Yet, another miscarriage of injustice was the fact that almost every single one of those jurors had already watched the documentaries. Make that one make sense. Anyways, thank you guys for watching. If you wish to see more from me in the future, go ahead and like, subscribe, and share. Thank you.